NACDL is the association of the nation's criminal defense bar.
So Ron is and has been my investigator. I talked him out of working for the State Patrol. What year, Ron?
2002.
2002. And so Ron is a DRE instructor. He is a standardized field sobriety testing instructor. And he was one of the toughest witnesses to beat when I was a prosecutor back calling him a witness, largely because Ron was by the book and he was nice to people on the street, right? Give me a good cop who wants to cut corners and who's nasty to my client on video, and I've got something to work with. Ron didn't leave much to work with. What I've asked Ron to do here today, and I did this at Harvard this summer at the National College for DUI Defense, so if you saw this before, forgive me. I was just asked to do it here again. It is a demonstration of some of the common topics that we see in DUI cases. So for the first 10 or so minutes, what I'd like to do is outline for you some of the techniques, some of the substantive methods and topics that I generally cover when I'm cross-examining a police officer. This is something that doesn't require you to hire an expert witness on. But to make me look good, I've asked Ron not to be that super cop that he was, and to be kind of consistently what many cops are, not too obstinate, not too dumb, somewhere in the middle. So Ron, if you can just dumb it down for us just for a little bit,
yes,
just
sir.
Make me look good, that would be good. If you want, what I'm going to do is that's going to be your seat over there.
Okay.
If you'll just sit there and kind of face me kind of a little bit that way, yeah?
Put me
Move
in
it
the
over
broom
just
closet.
a little bit.
You got me in the broom closet?
See?
You got me in the broom closet?
I got you in the broom closet.
All right.
And so let's talk a little bit about some DUI cross-examination techniques. And again, these are not complicated. Some of them you've heard, but what I'm going to do is kind of outline for you what I hope to accomplish in the cross demo. And what will happen is, as I'm cross-examining Ron, there'll be kind of a live, narrative taking place. There's two screens now. This usually would be right behind his head. But so you'll see kind of my commentary. Now, these are things that I'm not going to address. But while you're hearing my cross-examination, you'll see some either reference material or get an idea of what it is that I'm trying to accomplish here. All right, let's see if this works. Okay, the written materials. I know not everybody got the hard copy book, but if you have access to the written materials, I want to just mention two things, what's in there. There is a transcript that loosely follows the demo that we're going to do in just a minute. So again, you don't have to take a lot of notes. Most of the topics that I'm going to cover today are going to be in that transcript. The second is, and there's a couple of studies, by the way, that you'll learn. One of the things that I've learned to do over time is if I know a case is going to trial, I'll send some things to the police officer in advance. I'll talk about that in a minute. But the studies are in your written materials. There's just two studies I'm going to confront him with. But most importantly is you have access to these studies if you are a National College for DUI Defense member. We have a virtual forensic library that collects transcripts, collects motions, collects studies on all kinds of topics. It is the largest virtual forensic library in DUI defense in the world. Again, if you're not a member, you should be, because you'll have access to that. Okay, so let's talk about some time-tested cross-examination techniques. And again, some of this will be stuff you know, some of it may not, okay? There's a technique that I learned early on with Dodd and Posner. Everybody heard of Roger Dodd and Larry Posner? You know his cross-examination. It's the Bible for me for cross. Actually, for trying cases, it's the Bible for me. And one of the methods that he uses is you start off your cross and you lull the witness into a bit of a false sense of security by asking a string of easy questions that the answer is simply either a yes or a no. I choose yes. And then as the questions might get a little bit harder, you've already trained him, right? That the answer's yes, just come on, go ahead, say yes, right? So as the questions get harder. So it's called the path to agreement, okay? And it's a really simple technique. Another one is going to be what I mentioned before, and that is sending the arresting officer studies or articles or pages from training manuals. Now, I learned to do this again from another lawyer. A lot of the stuff that I'm teaching today I've learned from other lawyers. The great thing about this is you send these things to the police officer. Maybe it's a couple pages on horizontal gaze nystagmus from the training manual. Maybe you send him the transcript that you obtained of his training records that show when he took the intoxilizer course or when he took standardized field sobriety testing. Or in this case, you may have sent him a couple of studies, for example, on odor of alcohol or on red and glassy eyes. And the win-win is this. Either he reads them, right, and is prepared to answer questions about them, or he doesn't read them. And then you ask him during the trial, officer, did you get a copy of the study that I sent you from NHTSA? Yeah. Did you read it? No. This case wasn't important enough for you to review the documents I sent you? Well, I didn't know what you were up to with them, right? Well, you read the police report with the prosecutor in preparing for this, that sort of thing. So if he doesn't read them, it makes it look like either this case is important to him or he has an agenda, right? If he does read them, then it's in play. Trilogies, and there's two things. There's another thing I want to mention in the next slide just a second. Trilogies, you know what they are. We kind of think in things of three, but I want to mention something real quick. Can you see this article? Yeah. So another thing that I recommend you do in preparation is, just Google your cop. I have a case pending down in Noonan, actually where Ron is from, and in the case, it came back 0.10 alcohol, but it was a 0.05 Alka-Sensor, and there's a conversation on the videotape where this police officer, that one right there, Officer White, or Deputy White, you can hear him telling another cop, yeah, man, that's Xanax, right? You don't see HGN on 0.05 like that. That's Xanax right there. So we actually demanded that the crime lab in Georgia test this guy's blood for Xanax. He said, I've never taken a Xanax in my life. And it came back negative for Xanax. Now, we still got to fight the 0.10, right? But I couldn't pick a better headline. Look what they say. Drug recognition expert course helps law enforcement correctly identify, right? So I'm going to wait probably until maybe the day or two before the trial, and I'm going to send him this article and make him know that I'm aware of this. You can't change it. It's already out there. But we're going to have a little cross-examination. So Officer White, and that's the elected solicitor for the county standing next to him, by the way. I understand you were featured in the news recently. So do a little bit of homework. Get your police officers' training records, right? In Georgia, for example, we have POST, Peace Officer Standards and Training. We can now fax them or email them a request for any arresting officer's training records, and you get those back. And you'll see in just a moment one of the ways that you can use them to your advantage during your cross-examination. But trilogies, are the power of three. For whatever reason, we are all trained to think in threes, right? So you've got life, liberty, the pursuit of happiness. You've got duty, honor, and country, Father, Son, Holy Spirit, that sort of thing. Use these simple techniques during your cross-examination, and it will better the chances that jurors will retain the information that you're trying to get to them, okay? A couple other ones are establishing through clause what you need for closing. Again, you all know this. You are not going to win at the cross-examination. You're going to win because of your cross-examination. You're going to get what you need out of the witness during cross, and you're going to use it later in closing argument, right? So there's some, you've heard this, the notion, don't ask the one question too many. Well, that's true. But ask enough questions to give you the ammo that you need. So some of the things that you'll see in the running commentary on the screen are going to be examples of how I might use the information I'm obtaining during closing argument. We're also going to talk about semantics, language, right? This is really important to me. Saying, the state this, the state that, the state cloaks the prosecution in respect and credibility if you refer to them as the state. I suggest referring to them as the government, right? They're both correct. They're both, it is the government. But government is more of a devil word, right? When we think of government, we think of the IRS. When we think of government, we think, we're in a very divided country right now. Government has very much a negative tone to it, where state has a positive tone. So you'll hear me do my best at times to choose my language carefully to support my position, right? And then comparing the government scoring system, right? Let me ask you guys this real quick. How many of you DOI practitioners have the NHTSA manual in your library, okay? Well, let me ask it the reverse way. Who doesn't have this manual? Don't be embarrassed. Some of you are not full-time DOI practitioners. If you don't have this manual, get it, study it. If you can find a course to take this, it will save you money in having to hire experts if you do that. I just learned through Gerald Lippert that these actually can be ordered today. They have some here through the NACTL desk, okay? So this is the police officer's training manual. Virtually every officer in the state of Georgia now is trained using the NHTSA guidelines. So I recommend getting this. I also have here that I did an open records request, the Georgia Operator's Training Manual for the Intoxilizer. Chock full of good information. It has the course outline, for example, of what the police officers are taught and at the hour and the time and that sort of thing. There's lots of good stuff about mouth alcohol in that manual. So get those things through open records requests. Get what you can, your officer's training records, in preparation for your pretrial motion and preparation for trial. And these are things that you can use. And when I talk about comparing the government scoring system to the spelling bee scoring system, those of you who are familiar with NHTSA realize that the NHTSA scoring system only allows points to be taken off if you do something wrong. You don't get credit for anything doing right. So when we talk about 3 out of 8 on a one-leg stand, it means you did 3 things wrong out of the 8. You don't get credit for, like you would in the spelling bee scoring method, you don't get credit for what you did right. So that's kind of an overview of some of the topics that we're going to do. The last 3 things are going to be blood versus breath, attacking accuracy. In Georgia, the police are the ones that choose the type of test. I know there's some states where a defendant actually gets to choose. And then looping. Looping is a technique that you're probably familiar with, hearing something favorable the witness says and repeating it so it's beneficial to you. And then the last thing I think I mentioned was getting the cop's training transcript for use in cross-examination. Okay, so Ron, you ready for State of Bellagio versus Peter Sheffield?
Yes, sir.
All right. All right, so this is Peter Sheffield is my client. We're in the state of Bellagio. And so I'm going to begin the demo, and then hopefully we'll end with a little bit of time that I'm glad to answer any questions, and Ron's glad to answer any questions as well. All right, Trooper Lloyd, I'd like to talk to you about skills necessary to drive safely.
Okay.
All right? Can we agree that some of the skills that are necessary to drive safely include having good reaction time?
Sure.
Can we agree that in order to drive safely, one must have good mental alertness?
Yes.
Can we also agree that one would have to have good hand-eye coordination?
Yes.
In order to drive safely, one would have to have good vision.
That definitely helps, yes.
And also good peripheral vision.
Yes.
Right? And also, one would have to have good judgment in order to drive safely. You agree with that?
All those things make
All
it
right.
easier, yes, sir.
Let's talk about that. In order to drive safely, when a driver is driving their vehicle, they have to have good hand-eye coordination, correctly?
Yes.
In other words, a person needs to be able to use the steering wheel properly, use the turn signals properly, correct?
Correct.
In fact, you have to have really good foot coordination because you need to operate the pedals for the gas and for the brake, correct?
That's correct.
And they would also have to have good vision. For example, in this case, my client pulled over right away, correct?
Correct.
Was able to see your blue lights.
I guess he did. He pulled over.
And in the rearview mirror had good peripheral vision because you would have to look out your peripheral vision and see that and be able to pull over.
Yes, sir.
Person would also have to have good judgment. For example, included in good vision is to be able to judge the distance from the curb.
Sure.
And in this case, my client pulled over normally.
Yes, sir.
My client pulled over timely.
He did.
And pulled over in a proper manner.
He did.
So the stop was normal, timely, and proper. Agreed?
Agreed.
You stopped him only for exceeding the speed limit, correct?
That was it. Yes, sir.
Okay. When we talk about what you first observed in having contact with Mr. Sheffield, you testified on direct that you smelled an odor of alcohol and you saw red and glassy eyes, correct?
Strong odor. Yes, sir.
Strong odor. And you call your previous testimony from the driver's license hearing in this case
Yes, sir.
where I inquired about these questions.
Yes, sir.
And at that hearing, do you recall me providing to you a number of studies that have addressed the validity of sensing the odor of alcohol and red and glassy eyes? Do you recall that?
I do. Yes, sir.
And how do you recall that, Trooper Lloyd?
You gave them to me and sent them to me and asked me to review them and be prepared to talk about them.
And did you take the opportunity to review those articles?
I mean, I didn't read it word for word, but I did look at it. Yes, sir.
Okay. As it relates to the odor of alcohol, are you familiar with the study that I provided you, the NHTSA study that involved Marceline Burns?
I am now, yes, sir.
And tell the jury who Marceline Burns is.
Well, she's kind of considered the godmother of field sobriety from the Southern California Research Institute. She was the lady that was in charge of the contract that NHTSA formed with that agency to develop the standardized field sobriety test battery.
Mm-hmm. And so you read police officers' detection of breath odors from alcohol ingestion, correct?
Yes, sir. Like I said, I did skim over it. I didn't read it word for word, but yes, sir.
Okay. Well, I'm going to hand you a copy of that study. If you need to refresh your recollection, I invite you to do that. We can agree that in these studies, it was determined that estimates of strength of the odor of alcohol are invalid as to identifications of the beverage consumed.
Yes, sir. That's what it said.
In other words, the odor of alcohol, whether it's mild, weak, or strong, is not considered a valid predictor of blood alcohol concentration.
No, sir. Not according to this study.
It cannot determine the number of drinks a driver has had.
That's what it says, yes.
And it cannot determine a person's ability to drive. You agree with that?
According to this study, yes.
Okay. We also discussed the study regarding bloodshot eyes. Do you recall that?
Yes, sir.
Okay, and I'll ask you to take a look at that study. If you need to refresh your recollection, I invite you to do that. You would agree that bloodshot eyes, while associated with alcohol consumption, is also a trait, for example, of many shift workers, people who work more than one job, as well as those afflicted by allergies. Do you agree with that?
I do.
So, I know it's not part of your training, but the same people who established your training that performed these studies have reached the conclusion since your training that odor of alcohol cannot determine BAC, number of drinks, or ability to drive. Agreed?
Agreed.
And the red and bloodshot eyes similarly cannot determine a person's blood alcohol concentration.
That's correct, according to the research.
Cannot determine the number of drinks a person has had.
That's correct.
And cannot determine a person's ability to drive.
Yes, sir.
All right. Let's talk about the testimony that you gave regarding the first test you did, and that is the horizontal gaze nystagmus.
Yes, sir.
Do you feel that you did the horizontal gaze nystagmus in this case properly according to your training?
I do.
And in this case, your testimony was that you saw 6 out of 6 clues, correct?
That's correct.
We can agree that everyone has horizontal gaze nystagmus. Alcohol is one of the things that makes it more visible. Agreed?
Yes.
Okay. There are a number of other things that can cause visible horizontal gaze nystagmus, correct?
Sure.
A person who is extremely fatigued.
Possibly.
Cigarette smoke.
I mean, I don't remember hearing that one, but if you say so.
But there are other things, according to your training, that can be the cause of horizontal gaze nystagmus that has nothing to do with alcohol. Agreed?
Yes.
And you mentioned that you felt that you performed this according to your training. Do you feel you got a valid result in this case?
Absolutely.
In order to get a valid result, the driver that you're evaluating cannot move their head, correct?
That's correct.
In other words, if a person moves their head and not just their eyes, it would invalidate your conclusions.
Well, I mean, there's nothing in the training that says it would invalidate it, but the officer would definitely want to stop, re-instruct, and redo those portions of the passes.
So in other words, if a person were swaying, they would by definition be moving their head if their head was moving with their body.
Yes, sir, technically.
And you associate swaying with somebody who is under the influence of alcohol, correct?
That's one of the things we look at, yes, sir.
You did not see Mr. Sheffield sway during the horizontal gaze nystagmus test.
I mean, I don't remember if he did.
Okay, you certainly would have put that in your report if you had seen that.
Yes, sir.
You did not see Mr. Sheffield sway during the horizontal gaze nystagmus test, did you?
Not that I recall, no.
Okay. Let's talk about the walk and turn test. Okay? And you testified, the prosecutor asked you about your training and that there were studies that validated these tests, the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand. You recall testifying during direct that according to your training, that those tests have been validated by the National Highway Traffic Safety Administration?
Yes, sir.
Let's talk about the original findings of those NHTSA studies.
Okay.
You testified, for example, that horizontal gaze nystagmus was considered the most accurate of the three.
Yes, sir.
And it was comparatively to the walk and turn and the one-leg stand the most accurate
Yes.
at predicting a person above or below a .08 BAC, correct?
Yes, sir.
And how accurate was the horizontal gaze nystagmus if done correctly?
Based on the original research?
Original research.
I believe it was 77%.
77%. So that would mean, Trooper Lloyd, that of 100 suspects that were studied, 77 of them were classified correctly and 23 of them were misclassified, correct?
That's the way I understand it, yes, sir.
Meaning some of those that may have been under the influence were classified as not under the influence, and some of those who were not under the influence were classified as being under the influence. Agreed?
Yes. Yes.
On the walk and turn, how accurate is the original research? It's less than the horizontal gaze nystagmus, correct?
Yeah, it is. It's 68%.
68%, right? So using those numbers, 32% of the people would be misclassified, correct?
Yes.
And on the one-leg stand, tell the jury, Trooper Lloyd, the accuracy of the one-leg stand.
I believe it was 65%.
65%. So there, 35% of those would be misclassified, correct?
Yes, sir.
All right. So I want to turn our attention, move on from horizontal gaze nystagmus now to the walk and turn test.
Okay.
Do you feel like you obtained a valid result according to your training in the walk and turn test?
Absolutely.
In your training, we talked about the studies, but in your training, you had to become certified to administer these field sobriety tests, correct?
Yes,
And you took a 3-day course,
I did.
a 24-hour course.
Yes, sir.
And during that course, you were taught substantively what you were going to be tested upon at the end, correct?
Yes.
There was a test.
Sure.
It was a test that you would either pass or you would fail. Agreed?
Right. Yes.
And you had to score a minimum of 80 on that test in order to pass.
That's correct. Yes, sir.
Did you pass the first time?
I did.
Congratulations.
Thank you.
In order to pass, did you have the opportunity to study the material that you were taught?
Yeah, they gave us time to study it.
In order to pass, did it also include having to administer the field sobriety test in the presence of an instructor?
Yeah, we also had to pass a proficiency examination.
And were you given the opportunity to practice before you were given the exam?
Yeah, they gave us several hours of practice.
In fact, you were paired up with another cadet at the time and were basically given the opportunity to administer these field sobriety tests and practice on them for each other.
Yes, we were.
When you asked Mr. Sheffield to submit to the walk and turn test, did you tell him what a passing score was?
We're not required to do that.
Did you tell him what he was going to be graded upon?
I gave him the standardized administrative procedures, but specifically telling him what was a validated clue and what wasn't. I mean, I didn't tell him that.
So there are 8 validated clues on the walk and turn test.
Yes, sir.
Did you list for him what the 8 things that he was going to be asked to perform correctly so he knew while he was taking the test that those were the things he was going to be graded upon?
Not necessarily, no, sir.
Okay, no, the answer is no, you didn't do that.
Well, yeah, I mean, I guess during the instructions, part of the things you're telling them to do, common sense says you don't do the opposite. So,
Well, for example, you asked him to stand with his left foot on the line and place his right foot in front of him.
right?
Did you tell him if he didn't do that or if he stepped out of it, you would mark that as one of the 8 clues? Did you tell him that?
I mean, I didn't tell him that. I just told him to hold that position until I asked him to begin.
You also told him during the instructions that not to begin until the instructions were concluded, correct?
That's correct.
Did you tell him that if he began before the instructions were included, that you would mark that off as a point against him, as a clue?
Not necessarily.
And as I understand it, that is during the instructional phase, correct?
It is.
Did you tell him that there were 2 phases to the test, the instructional phase and the walking phase?
No, sir. We're not required to do that.
Did you tell him that there were 2 clues that you were looking for during the instructional phase?
No, sir.
Did you tell him there were 6 clues that you were going to look for during the walking phase?
No.
Did you give him the opportunity, as you had in your training before your exam, to practice?
No, sir. We don't have to do that.
And you didn't do that?
No, sir.
All right. I want to talk to you about once the walk and turn examination began, what you're looking for, okay? We can agree that during the walking phase, there are 8 opportunities on the way out. I'm sorry, 9 opportunities, forgive me. 9 opportunities on the way out, for example, for a person to stop walking.
Sure.
There are 9 opportunities on the way out for a person to step off the line.
Yes.
One of the clues you look for is using arms for balance. And if you were to, a suspect were to have their arms more than 6 inches out on each step to try and balance themselves, that you would mark that as a clue.
Yes, sir.
You would agree that there are 9 opportunities to see a person steady themselves by using their arms for balance on the way out.
I would.
And on each of these questions I'm asking you, there are 9 steps on the way back. Agreed?
Agreed.
And you would agree that there are 9 opportunities for each of those to be seen on the way back.
Yes.
There's 1 turn.
Yes.
It's either done correctly or incorrectly.
That's right.
Right? And then we already mentioned that there are the 2 instructional phase clues, whether the person breaks out of the position and whether the person starts too soon. They either do that or they don't do that. Correct?
That's right.
All right. Your testimony was that you saw 3 clues out of the 8 that you were looking for. Agreed?
Yes.
Let's talk about how you score a walk and turn test. Okay? You are required to use the government scoring system that you were taught by the National Highway Traffic Safety Administration. Let me be clear on what I mean by that. Your training is that you are to look for particular clues, and if you see them, to mark them down as a clue.
That's right.
You are not allowed to. In fact, it would be contrary to your training from the National Highway Traffic Safety Administration to give a person credit for each of the things that they did right during the exam. Agreed?
Well, yeah, they don't teach you to do that. They just teach you to mark the things that they actually did wrong.
Okay. So if you were, for example, to use what I'll call the spelling bee scoring system, which means if my 10-year-old son has a 20-word spelling test and he gets 18 of them right, that he would get credit for getting the 18 right. He wouldn't just get marked for 2 off. Agreed?
Sounds reasonable, yes, sir.
Okay. But the NHTSA scoring system doesn't allow you to do that. The NHTSA scoring system only allows you to take points off for what was done wrong. Agreed?
Yes, sir. That's the way it was set up.
All right. When you had Mr. Sheffield perform the walk and turn in this case, was there an actual line that you used?
Imaginary.
An imaginary line?
Yes, sir.
All right. Now, he was stopped on the roadside. There was actually a line there, but you chose not to use that, correct?
I prefer the imaginary line.
You do?
Yes.
Can you tell the jury how wide your imaginary line was?
I mean, I guess about as wide as a fog line or a parking stripe.
Did you tell Mr. Sheffield that that's how wide the imaginary line was going to be?
No, sir. I just imagined that he would imagine it the way I imagined it.
How wide was the line that Mr. Sheffield imagined?
I imagined the same as the one I imagined. I mean, I would say the fog line width, but I don't know for sure.
Do you imagine that the imaginary line that Mr. Sheffield was imagining was different from the imaginary line that you were imagining?
I really don't know. I mean, I don't know what he was imagining. Now that you mention it.
Let's turn our attention now to the breath test. Can you tell the jury whose decision it was to designate the type of test in this case, blood, breath, or urine? Was it Mr. Sheffield's decision?
It was my decision.
It was your decision. Can you tell the jury what type of test you chose?
Breath.
Breath test. Are you certified operator on the Intoxilizer 9000?
Yes, sir, I am.
And you've been through the training?
I have.
Could you have chosen a blood test in this case?
Sure.
Can we agree that a blood test is more accurate than a breath test?
Well, they're all accurate.
They're all accurate. Are they equally accurate?
I mean, I'm not a scientist or anything or a toxicologist, but the state tells me that they are.
Okay. When you arrested Mr. Sheffield and you read him the implied consent warning, which tells the driver what his obligations are to take a blood, breath, or urine test, there is a space in there that says designate the type of test.
That's right.
And that means you designate it, not Mr. Sheffield.
That's right.
And you designated breath in this case.
I did.
Do you recall when you arrested him, you informed Mr. Sheffield that he was being arrested for suspicion of DUI?
I did.
And when you read him the implied consent warning, were you reading that because you believed, you suspected him of DUI?
Yes.
And when you put him in the police car, you were placing him under arrest for suspicion of DUI. Agreed?
Yes.
And when you designated the breath test, let's talk about the decision that you made. You are authorized to choose blood, breath, or urine, correct?
Yes, sir.
Okay. And can you tell the jury what the term BAC stands for?
Blood alcohol concentration.
Okay. What was the blood alcohol concentration result in this case?
I believe it was a .094.
Okay. Is there a blood test in this case?
No, sir.
There's no blood test in this case, but you just told us that the blood alcohol concentration result was .094.
Yes, sir.
We can agree that according to your training, you are taught that a breath test is acceptable under Georgia law as an estimate of what the blood alcohol concentration would be if it were blood.
Yes, sir.
Okay, so when you ask for this estimate of what the blood alcohol concentration would be, you perform the breath test yourself.
I did.
And when you designated this test that is an estimate of what the blood test would be had you requested blood, you administered the test using your training.
I did, yes, sir.
And when you had Mr. Sheffield blow into this machine that produces the result that is an estimate of what it would be if it were a blood test, do you feel you obtained a valid result?
I do.
Okay. Let's talk about that result. I'm going to hand you a copy of the breath test slip in the case. And if you'll just take a look at this. Do you see where on there it says above the results G/210L?
I see it, yes, sir.
We can agree that the breath test in this case was expressed in grams of alcohol per 210 liters. Agreed?
Yes.
And when we talk about 210 liters, did Mr. Sheffield actually blow 210 liters into the machine?
I got no idea. I'm from Porterdale, Georgia, man. I don't understand all that science stuff.
Okay. All right. Well, let's talk about your training. Do you know anything about the internal workings of the intoxilizer?
Not really. They told us we didn't need to know that. They just told us we needed to push a button, type in the information, and have them blow.
Okay, so you don't need to know anything about the internal workings of the machine.
I mean, they mentioned it in our training, but, I mean, they said if it's asked on cross-examination, to just say you just operate the machine.
So you were actually trained how to answer, for example, questions from a defense lawyer asking about the machine?
Yes, sir.
Okay. Officer, where were you on April 20th, 2015?
I have no idea.
Well, I'm going to hand you a copy of your training records. This is the Peace Officer Standards and Training transcript. And can you take a moment to review that? And I'll ask you the same question.
Okay.
And looks like April 23rd, 2010, if I'm reading that correct. Where were you on that date at approximately 1 to 1:50 p.m.?
Looks like I was in my intoxilizer training.
Okay, and during that period of time, what was the topic that was being discussed? According to the syllabus there in your training.
I mean, something to do with the way the machine works.
Okay. I'm going to show you the Intoxilizer Operator's 9000 training manual. And at the beginning of it, Trooper Lloyd, you will see that there is the class schedule on the first day and on the second day.
Yes, sir.
Take a moment to review that, and I'll ask you the question again. Where were you on the first day of your class between 1 and 1:50 p.m.?
Can I borrow your glasses? Sorry. When you turn 50, it goes downhill. All right, so what was the time again?
1 to 1:50.
All right, here we go. Respiratory anatomy and general principles of breath alcohol testing.
Okay, can I borrow my glasses back?
Yes, sir.
You can hang on to that.
Thank you.
Respiratory anatomy and general principles of breath alcohol testing. All right. So, you've told us you don't understand or you're taught not to answer questions about the internal workings of the machine, correct?
Yes, sir.
All right. We can agree that an intoxilizer takes a sample of breath that is blown into the machine by the driver. Agreed?
Yes.
And there is a sample chamber where that sample is blown into, correct?
I mean, I guess. I mean, I know it was a part of my training, but I really just don't remember all that.
Well, if you need to review the Intoxilizer 9000 training manual and take a look at it, I'll ask you a few questions about it.
Yes, sir.
We can agree there's an approximately 80 cubic centimeter sample chamber where the breath is blown into, correct?
Yes, sir, that's what it says.
And the way the Intoxilizer measures, or at least attempts to measure, the alcohol level in the breath sample is a light turns on, right?
Yes,
and
sir.
we're talking about infrared spectrophotometry. Agreed? You remember that?
No, sir, but yes.
Okay. And all that means is a light-based measurement, right?
Yes.
The intoxilizer measures the decrease in light from one end of the chamber to the other end of the chamber. Do you recall that from your training?
No, but it does say it here.
Okay. Is that your training manual?
It is.
When the decrease in light is measured, it gives us what the estimate of the blood test would be, correct?
Yes, sir, that's what it says.
Okay. And from that estimate of what the blood test would have been had you requested blood, it's expressed in grams per 210 liters, agreed?
Yes, sir, that's what it says.
So we're going from an 80 cubic centimeter sample chamber to 210 liters, agreed?
Yes.
And Trooper Lloyd, can you picture for a moment on this stage what 105 2-liter bottles of Coke would look like?
I can imagine, yes, sir.
Okay. So there is an extrapolation, for lack of a better word. Again, when we're talking about taking the estimate and expressing it in what it would be in grams per 210 liters, there is a conversion ratio, agreed?
Agreed.
Okay. And then lastly, Trooper Lloyd, your testimony regarding your opinion that Mr. Sheffield was less safe to drive.
Yes.
We can agree that opinion is different from a fact. Agreed?
It is.
For example, it is a fact that I have a bald head. Agreed?
Absolutely.
Well, some might have the opinion, like my wife, that she likes my hairstyle.
Yes.
Some may not.
Yes.
We can disagree on opinions. Agreed?
Sure.
Okay, thanks. That's all I have. So, all right. Ron, good job.
Thanks. Thank you.
He was a little bit of a patsy, but hopefully you all were able to see some of the things that we were trying to accomplish here. And I think we have a few minutes left. And what I've invited Ron to do that I thought would be valuable is he has experience, years of being a prosecution witness. He has experience in being an expert witness for the defense in criminal cases and in civil cases. You and I prepped this a little bit, so you knew what the questions were going to be. Can you share with us, as lawyers, maybe some insights into your experience in the pitfalls that you see in dealing with lawyers that have hired you? What advice would you give to attorneys, for example, who might be using a field sobriety expert for a first time, someone who can testify about all the things that I went over, the basics of the intoxilizer? I know you're not an intox expert,
right,
but I know you're trained and you're certified on the intoxilizer. Would you mind just sharing us with a few insights, and then if we have time for a few questions, that'd be great.
Yeah, probably the most important thing I could share with you is that, and actually when I was a state trooper, a young state trooper, and Mike was a prosecutor, he actually taught me this a long time ago, was that probably the best thing you can do for yourself is to be prepared. And come to these conferences. This is what gives you that education and that experience, taking it back and using it in the field, that makes you actually successful at this. And Mike always told me, he says, I may not be the smartest person in the courtroom, but I'm always going to be the most prepared. So I say that to say this, that if you ever are going to use a field sobriety expert or a drug recognition expert, please take the time. If you're going to hire them, take the time to spend some time with them first let them review the case and let them give you their opinion, and then tell them how that equals out with what you anticipated their testimony would be, and you guys talk about it and figure that out together. Because probably when Mike's talking about pitfalls of working sometimes with lawyers, I don't know what it is. Some lawyers are phenomenal about wanting to spend an extreme amount of time in preparation so there's no surprises or ambushes during trial. And some of them, they're saying, look, I'll see you in court. Don't be that lawyer. That's all I ask if you're going to use an expert. Because the worst thing that you can do when you hire an expert is get them on the stand and ask them a question about something that you're not sure about, and their answer actually hurts your case because the expert is in a position they have to tell the truth. And so that's really probably more than anything is the preparation with your expert if you're going to use one.
One of the things that Ron and I have talked about that I've tried to do, that I had to learn by trial and error, is you kind of prep this type of an expert witness if you're going to use someone like Ron to discredit field sobriety tests, right? Now here in the demo, he was the state's witness. But I've used Ron a lot as, if I watch a videotape and I see that field sobriety tests are being done incorrectly, Ron can actually issue a written report. Sometimes I'll provide it to the prosecutor because they may be willing to negotiate a better deal, a reckless driving rather than a DUI. Other times, if I know it's an obstinate prosecutor, it's just a case that's not going to get negotiated down, he'll send me a report on what he sees was done incorrectly. And the errors that I made early in my career was I would prep those things and I would get all this great information out of Ron, and then the prosecutor would stand up and ask pretty simple questions like, Mr. Lloyd, isn't it true that you are trained that if you see 6 clues on an HGN that you would need to make the arrest decision?
Yes.
And he has to say yes. And if you've got 6 clues in your case, now the prosecutor is kind of using your witness to establish their case. So it's going to be uncomfortable, but you need to ask those questions yourself, and you need to prep them, right? You need to anticipate, and the way I learned to anticipate it is I got transcripts of the loss where he got beat up pretty bad, and I said, okay, I'm going to find a way to ask those questions that hurt me the most with Ron having to answer honestly and made the case for the prosecution. And it would look something more like this, and Ron and I would talk about this. And this is me as the defense lawyer asking Ron this question. Trooper Lloyd, you would agree that according to the NHTSA training, if a test is done properly, then 6 out of 6 clues on a horizontal gaze nystagmus test would mean that you would make the arrest decision.
Yes, if it's done properly.
Do you have an opinion in this case as to whether the conclusion of 6 out of 6 clues is a valid result?
Not based on the way the officer administered the test, no.
Tell the jury why.
Well, because he didn't medically qualify him, he didn't do any equal tracking passes. We can't rule out the fact that some medical condition or injury may have been causing the nystagmus that the officer observed. So without having that medical qualification the officer is trained to do, he has no idea if what he actually observed was from the alcohol or drugs or if it was from some kind of other medical condition or injury.
Right. So while that's taking place, the prosecutor is scratching through that question on, their thing. Or if they do ask it, Ron will come back and say, well, as I said, a few minutes ago, if these tests are done properly, they can lead to a valid conclusion. In this case, I cannot express that opinion because they were not done properly. And it's not, it's like anything. If you're a sports fan, you want to play offense, anticipate what the defense does. If you want to play defense, get inside the other side's playbook for offense and learn to adjust to it. A lot of lawyers hire someone like Ron and think, man, this guy's going to win my case for me. And they end up with the prosecutor making more headway on it. Did you have a question, sir? I have not. The question was, have I filed a motion to exclude the questions about medical qualification? And on what grounds? You mean not just HGN, but if you're medically qualified? Okay, so you're from Hawaii, correct? So apparently Hawaii has some judges that are addressing the issue of whether medical rule-out questions can be admissible because they're in violation of Miranda. That's an interesting legal argument. Do you have any opinions on it yet? Do you have anything written yet? And that's suppressible at the initial parts of a DUI investigation. I'm going to repeat the question. The comment is that the challenge has been that questions, are you taking any medication? Do you have any medical disabilities? Those should be excluded under Miranda under Hawaii law. Is that correct? I mean, I can show you there's a truckload of cases in Georgia that would say initial questions by the police to determine the nature of the situation, if a driver is impaired, are not custodial. They are during that time where it's considered you're detained, right, but not under arrest. And our cases say what a lot of state cases are. There are 3 tiers of police-citizen contact, right? Consensual contact where the Fourth Amendment is not implicated, a temporary detention to determine whether a further investigation needs to be made, and probable cause, right, to arrest. What I hear you saying is that a determination is being made that a person's in custody at that point and when they're being asked medical questions. I hate to be so cynical, man, but that would never fly in Georgia. I need to open an office in Hawaii, I guess, for a variety of reasons. But that's very creative lawyering. I think it's brilliant. If we do reach a point, of course, in any case, I think it's legitimate to always file a motion regarding incriminatory statements and incriminatory acts, which, think about it, field sobriety tests, they're not statements for the most part, they're incriminatory acts. So the federal protections would not apply because that only applies to evidence that's testimonial, right? I guess ABCs might be testimonial, right? But anyway, that's an interesting comment. Yes, sir. Well, I think you do what I described before. I mean, it wasn't part of this. Perhaps it should have been. It's a pretty easy question. You always want to be the one to ask that question. You want to ask how much the expert's being paid. Don't leave that to the prosecutor. That's a perfect example. Because if the prosecutor gets to ask that question, it could reverse the momentum, right? And you can train a witness to politely answer that question, or if the prosecutor's going to make an issue of it, you can train him to answer the prosecutor's question so it doesn't look like you can this answer. And that is, and you'll get prosecutors to say, how much are you being paid for your opinion? And the answer would be,
well, I'm getting paid for my time and travel to be here.
That's right. Just as the bailiff is, just as the jurors are getting their $25 a day, just as the judge is, just as the prosecutor, we're all getting paid to work, right? The witness doesn't do this for pleasure. Of course he's paid. The amount of time and resources that he puts into evaluating the case, you can say what your hourly rate is, or if it's a flat fee. And if it's something that will raise his eyebrows, if it's $2,500 and you're in a somewhat modest rural community, and man, that's a pretty good fee for a day's work, and that's what it looks like. As the lawyer calling this witness, I think it's important to establish what's included in that fee. Does it include travel? Does it include, and a lot of times, you guys know this, he's sitting in the hall for 6 or 7 hours before we get to him. That's time lost. And if that happens, you need to be the one to bring that up, because if all that comes out, as my friend from Colorado says, is the first question from the prosecutor is, how much are you getting paid for your opinion? He looks like a hired gun, okay? And so have you had that experience, Ron?
Absolutely. And what I tell every defense lawyer that hires me, and by the way, it's an outstanding question, it's probably the most important question that you can ask if you're going to hire an expert, is you always want to be the one to get that out in front of the jury. Don't let the prosecutor steal their thunder on that. And, and when the prosecutor does somehow ask me that first, I always just try to loosen up the jury, and I say, absolutely, my wife insists on it.
Right.
And the jury falls out laughing. And then they love me, and they think he's a jerk. I mean, it just happens that way. I mean,
yeah. And don't forget, one of the things that, that I tried to make a little bit unique about this is what's going on, the commentary is, and you saw, for example, and what I want to do in just a moment, if we have time, is to just do a quick review. So you saw where I was going, if it was not immediately clear, is that even if it didn't come out during the testimony, you in closing can say, if the prosecutor says, and they brought in this hired gun, or some even would say this whore, whatever, depending on where you are. Sorry, Ron. Well, so that may or may not be beneficial to the prosecutor to use that kind of language. Probably not. But the point is that you can say what I just said is, do you suppose the judge is getting paid to be here, or is he working for free? You suppose Madam Prosecutor is working for free, or is she getting paid? And you can kind of joke, like Ron said, in our jurisdiction, you get $25 a day for being a juror. Most people are losing money on the deal. You're getting paid, even though it's grossly inadequate, and they'll smile and they'll nod, yeah, what a bad deal this is. But the point is made. And the point here is, don't let them make the point, address it, get out in front of it. Okay.
And one way I always answer it too is that, if they make a big deal about the fee, it's the industry standard. I mean, we don't always agree or like what professional athletes get paid, but you know what? It's the industry standard, so that's what they demand. And that's, most people get that.
Yeah.
I mean.
So just a quick review, if there's not any more questions. Path to agreement, this was easy, right? The way that I chose to do this, and decide if you're comfortable with this. Some judges won't let you do what I did, right? I like to, particularly after a long direct, I like to get the jurors' blood flowing a little bit, get them interested and not just be a talking head. And so I'll pull my chair out there and I'll sit in the driver's seat. And I'll do what I did and sort of demonstrate what good hand-eye coordination is, what good peripheral vision is, what good judgment is in detaining those. If you're not comfortable doing it, don't do it. If your judge won't let you do it, don't embarrass yourself in front of... There's a judge in Rockdale County, Sidney Nation, would say, Mr. Hawkins, you need to get back behind the podium, right? And so, and that's what we get paid to do, is to know our judges too. So that's one thing. It's not really a trick, but it's something that's interesting to the jurors because it gives them a little bit more of a visual. Some of the other things here, I want to say a word about this. For those of you who get jury trials, this is a great way to make jurors on your team. And that is during jury selection, say, can anyone here tell me what skills you believe are necessary to be a safe driver, right? Everybody's going to raise their hand. You got to have good vision, right? You got to have good judgment. You got to have good hand-eye coordination. And you know these things, right? And just write them down, right? Okay, these jurors said this. And then those become your questions during the direct of their cop on skills that are necessary to drive safely, right? These are softballs. Who's going to say no to these, right? He's going to say yes to all of them. And those are the questions that you establish through the jurors that now become part of your trial. And if you choose, like I said, you can go through and demonstrate all the things that your client did right. How am I doing on time? Okay, good. So if you get driver's license hearings, you get motions hearings, I'm a big advocate, if your client can afford them, to get transcripts from them. Almost invariably between a driver's license hearing or if you get a pretrial motions hearing in a trial, there's going to be slight differences in what the testimony is. You need to have those transcripts there and use them. And also you're asked those questions without the jury being there, so you know better what the answers are, so it'll go a little bit more smoothly. Again, these two studies are found in the virtual forensic library. I also put them in your materials. They're not home run winners, but they do chip away. And that's the name of the game in defending these is the jury's not going to decide guilt or innocence based on odor of alcohol. They're not going to decide it based upon red and glassy eyes. But if that's what the prosecutor has their laundry list of all the reasons why they should find him guilty, I say this in closing. If the prosecutor tells you that you should find him guilty because of odor of alcohol, will you just do Mr. Sheffield a favor and remember that the trooper told you that there are studies that say that those are not valid for determining blood alcohol concentration, not valid for determining number of drinks, and not valid for determining if a person's safe to drive, And I do that a lot because prosecutors in my jurisdiction get the last word, right? And so it's really empowering in my view to, during your closing argument, say to the jury, I've stated for you my reasons for doubt, right? And that's one of the things I do is that you're going to be asked to find proof beyond a reasonable doubt. I'd like to talk with you now about some reasons for doubt, right? And what your reasons for doubt may be different from your fellow jurors' reasons for doubt. Your reasons for doubt may be different than my reasons for doubt. But would you consider this after you elect your foreperson? Would you consider before you just take it to a vote to do what the judge will instruct you, and that is, before you can find someone guilty beyond a reasonable doubt, maybe take a few minutes and each of you list your reasons for doubt, right? And before you have a conversation about that, go ahead and take a few minutes, list your reasons for doubt. And if you start to find that there are common reasons for doubt, or if there's a reason for doubt that one of your fellow jurors thought of that you didn't and you think it's valid, include that on your list. And then, ultimately, when you're asked to make the ultimate determination, are you comfortable knowing that you have a laundry list of reasons for doubt? And then one of the other things that I do, for example, in this case it was speeding, no real traffic violation, is we'll concede the speeding, right? We'll concede, say, we're not here to fight about speeding. He was probably going over the speed limit. We're not here to fight about radar evidence. But I want to ask you, ladies and gentlemen, to do this. Think about the speeding charge and then think about the DUI charge. Think about your comfort level, whether the state has proven their case beyond a reasonable doubt on the speeding charge. Think about that for a moment. And then think about the level of proof on the DUI. Was there any falling off? Was there any hesitation on your part? Did you feel like they proved it less on this? If that's true, that is the doubt of the law, and the judge will tell you that it is your duty to acquit if you do not feel that it was proven beyond a reasonable doubt. And what you're doing is, you can see what you're doing, is you're taking the easy charge, right? Conceding it, or if you want to fight about it and they've proven it, or if it's on video that your client ran the red light, whatever the case may be, you can sort of juxtapose, though. There's a good $7 word, juxtapose. The charges, the stopping charge, the traffic violation with the DUI, and you can sort of use that as a method of demonstrating reasonable doubt. Okay. So again, yeah, these aren't home run things. And the trilogies you saw, HGN not being alcohol specific, this is the one I wanted to mention, okay? Don't ask this to a witness, okay? You're not going to ask, hey, Trooper Lloyd, if you had a headache and I offered you Tylenol, right? Now, 77 of the pills were Tylenol and 23 of them weren't. Would you take the pill? Objection, all this other stuff. But these are legitimate things. If the prosecutor's going to hang their hat on, these studies are so good and they're valid, that you can sort of put these things in your closing argument. Again, if you're comfortable with it, to demonstrate these are not 100% reliable and accurate tests, right? They are tests that are flawed, that people get misclassified, and the police officer's own training will demonstrate that people are misclassified. I want to fast forward over here. My language, right? Notice what I did when I cross-examined him on this. I didn't ask him how many clues there were. I asked him how many opportunities to show a clue there were, or to see a clue, right? And I used the government scoring system. And this is, see if I'm going the right way. I'm not, I'm sorry. This is a chart, again, not for cross, but you use the information you got during cross, and you put this up in closing. Now, I use PowerPoint when I teach because it helps me maintain organization. I don't use PowerPoint in the courtroom. I'm just not comfortable doing that yet. I also don't wear my nicest suit to court, right? So I am not going to put this fancy-looking chart with nice lines and numbers and things in there. I use 2x3 giant Post-it notes. Have you seen these? I mean, you got your little Post-it notes on your desk. 3M makes charts, and I travel around largely a 50-mile radius of Atlanta. Sometimes I go to a courtroom where they don't have a whiteboard. Sometimes I go to a courtroom where they don't have an easel. You can take these 2x3, right, poster boards, and they're just, you can peel them off, and they have, just like your little Post-it notes, they have the sticky stuff in there. And I've had cases where I've put them on the podium and given my closing argument here. And I've put them on the wall and given my closing argument. And you'll enjoy this. A prosecutor in Fulton County, when she saw mine, she had her little Post-it notes on her desk. She started writing, odor of alcohol, red and glassy eyes, whatever. And she started doing that. And during her closing argument, she slapped them on top of my thing. And the neat thing was they started falling off. In the middle of her closing argument, I was like, what a great visual, right? The state's case is falling apart. But as a lawyer, for me, I don't want to be viewed as too slick. I want to be viewed as conversational, as friendly. I will challenge a cop. I will not embarrass a cop. Most of the times in my jurisdictions, I don't have permission to embarrass a cop unless a cop's earned it and is acting like a jackass on the stand or maybe had done it on the street. But this is powerful, in my opinion. This is something that they can't get around. And, in closing, I do what I mentioned, and that is, say, look, do the numbers, and you can do the math right there for them. It turns out it's 3 out of 77 opportunities to see a clue is 93. In my house, if I got a 93 on my spelling bee, Mom put it on the fridge, and we all got ice cream, right? So people understand that kind of thing. The imaginary line nonsense, that's fun, but I'm not sure I would do it that way in court. But and then the breath test, this is a little bit different. I think it's important, and I know a lot of jurisdictions favor blood over breath. We get a lot of breath tests where I practice. Do not forget, breath testing is and will always be an estimate of what a blood test is. And so if the cop says they're both equally accurate, I promise you there's at least one juror that knows that that's not true. Or even better, he says, well, blood testing, as I understand, is the gold standard, but we're authorized to do breath. Right? That's the seeds that you plant for reasonable doubt, right? This case wasn't important enough to get a blood test. It would have been costly. There would have been additional witnesses. It probably would have cost the State Patrol money to do it, so on and so forth. They did what was expedient. They did what was quick. They got a breath test. It's nothing but an estimate. And then you're going to do what I mentioned is, anybody here ever get an estimate from a contractor, right? It's never the same. It's always, or the time horizon is always twice as long. Or even if you flew out here, anybody have a delayed flight? Estimated time of departure? It's never right. It's going to get pushed out more. So what you're doing is you're using devil words, you're using semantics, you're doing language, and you're beating them up with estimate. The other one is suspicion of DUI. I don't get that a lot, but I get it sometimes. And then you can use that kind of upside down chart for No reason to stop, reasonable suspicion, probable cause, preponderance of the evidence, clear and convincing evidence, and then proof beyond a reasonable doubt. And the cop's burden is way down here, suspicion of DUI. You can find Mr. Sheffield not guilty, and that's not a finding that the police did wrong. It's finding that he did his job perhaps in what he was trained on and got him off the street, but the evidence did not rise to the very high level of proof beyond a reasonable doubt, that kind of thing. And then we talked about estimate. And this is interesting stuff, but this holds true. As I understand it, every breath test, no matter what your machine, is expressed in grams per 210 liters. That's an interesting way to bring home. Actually, I had one police officer actually testify when I asked him these questions that my client actually blew 210 liters. Right? And then the last point is it's very valuable if you can get them to get your officer's training records. If you get the training records and you see he was trained in the Intoxilizer 9000, either subpoena it or do an open records request for it. We did an open records request for it, and we got the training manual, and it included the syllabus. This is right here, the first day of class, right? And you can see where they... By the way, we all get hours for CLE here. I learned when I got this that they get actually credit for lunch, right? They call it a 24-hour course, but it includes, non-teaching time. So anyway, those are some ideas about how you can prep for this, how you can deliver this, and hopefully it will make a difference in your case. And I appreciate you all listening. Thank you for having me.